So biodiversity net gain, or BNG, is a new requirement in planning law that requires qualifying development sites to deliver at least an increase of 10% to their biodiversity value. The idea is there will be measurably better biodiversity for developments compared to the state of the site before development took place. The actual value is calculated using a specialist biodiversity metric tool, normally to be used by specialist persons such as ecologists. The key, though, is that the 10% gain is measured against the starting value of the site, and the end development needs to be 10% better in biodiversity terms than the starting point. A site with a high starting biodiversity value will require even more improvements to achieve 10% net gain compared to a site with a low starting biodiversity value. Developers will need to be mindful of the BNG requirements right from the outset of their projects. For example, planning applications now need to confirm whether the development is exempt from BNG and, if not, the application needs to provide information on how the BNG objective will be met. Once planning permission has been granted, unless exempt, a biodiversity gain plan must be submitted and approved prior to the commencement of that development. The actual BNG delivery can take place either on-site, within the development itself, off-site, on land owned by the developer or through the purchasing of BNG units from land owned by others, or the purchasing of statutory credits. If the BNG is delivered on-site or on the developer's own land, the developer will likely need to enter into a Section 106 Planning Obligations Agreement to ensure the delivery of the relevant habitats and their maintenance for a 30-year period. The three methods of BNG delivery is known as the mitigation hierarchy. Developers have to first explore on-site delivery before resorting to off-site locations, and only if those are not available can they justify purchasing statutory credits. Where available, specialist off-site habitat locations have various advantages, from potentially providing better quality and more connected habitats, to saving developers the liability of delivering and maintaining the habitats for 30 years, to allowing developers to maximise the size and scale of their development within their site by not having to make room for unconnected habitats, to potentially making monitoring and enforcement more straightforward for LPAs. The use of off-site locations will have a big role to play in BNG delivery. The full impact of BNG on the development sector remains to be seen. There are, though, several points of note for insurers. BNG could give rise to increased uncertainty, costs or delay to development, meaning any insurance product relating to development delivery could be impacted. This new complex area of law could also give rise to liabilities for professionals involved in the planning and development process, such as planning consultants, architects, lawyers and ecologists. Developments will also be overshadowed by the risk of enforcement against professionals responsible for maintaining habitats, and there is a risk of events requiring reinstatement of BNG habitats within their 30-year maintenance period. However, with these risks comes the possibility of new products or services savvy insurers could offer, particularly in the currently immature marketplace. The BNG rules arise from a new and complicated area of law, so developers could benefit from input from planning lawyers at the outset of their projects. Whether advising on the BNG rules before site acquisition, working with your architects and planning consultants when devising your scheme, carrying out a strategic legal review of the application documents before submission to assist with validation and seeking to minimise the risk of judicial review, negotiating the Section 106 Planning Obligations Agreement, or advising on defending enforcement action, planning lawyers will be able to assist developers and off-site managers with all aspects of the BNG process.